Hi there, I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Okay, back to Voluntary Chapter 7 Bankruptcy, which is liquidation. We're at Part 2 now. So the objectives of this lecture include the Trustee Appointment, Trustee Powers, Claims, Motions, Creditor Complaints, and 341 meeting, Section 341 meeting, the Reaffirmation, Redemption, Discharge, Estate Distribution, and closing the case. So this necessarily comes after Part 1. We've got it filed, and now what happens? So first, there's appointment of and the primary role of the Chapter 7 trustee. At the time of the bankruptcy petition being filed, an interim case trustee is appointed from the Chapter 7 panel. And the interim trustee becomes the permanent case trustee at the time of the 341 meeting, unless another trustee is elected by the panel. And the primary role of the trustee is to administer the estate by reducing to cash the property of the estate that's not burdensome, exempt, or fully secured. The trustee of Chapter 7 trustee has a great many powers. On this slide, they can demand property held by another. They can abandon property of the estate. They can assume or reject executory contracts and unexpired leases. They can avoid unperfected security interests. They can avoid claims that an actual creditor could avoid under state law. The power to avoid statutory liens that arise they have the power to avoid statutory liens, power to avoid pre-petition transfers of property of the estate to creditors that are voidable preferences, the power to avoid transfers of property of the estate that are fraudulent, and the power to avoid post-petition transfers of property unless they're authorized by the code or by the court. Keep in mind that these are, this is a long list. Some of these terms you don't know yet, but we'll be covering some of these areas like avoidance, abandonment, assuming or rejecting, that sort of thing. So we'll be covering that in other lectures. So the creditors then, the vast majority of Chapter 7 cases are no asset cases. And so their proofs of claim are no longer, this is, I think, BAP CPA that brought this about, that Chapter 7 is typically a no asset case, and the B9, which is a proof of claim, it has this statement that says don't do this until the trustee believes there will be assets available to distribute. My experience back in the day when I worked in bankruptcy was they filed them anyway to protect themselves. If they believe assets will be available, the clerk will mail a notice and requesting creditors to go ahead and file. And they'll have at least 90 days for filing proofs of claims or interest. Claim can be contingent, unliquidated, or disputed. So contingent claims depend on some future event. Look at the situation like the lawsuit that's pending. The debtor has a lawsuit pending, maybe personal injury is a good example. There's no idea if there's really going to be an outcome. Unliquidated claim, this falls into some of the same category. Personal injury is a good example. What is the amount of the claim? You might have an idea, but you don't know for certain. And disputed claim is one that the debtor even contests. So the proof of claim or interest that the creditor files is allowed unless objected to by a party in interest. So the debtor, trustee, or debtor or trustee in that case would have the opportunity to object to the claim. Motions and complaints after the order for relief. There's another, at the very end of this class, I've got a longer lecture on motion practice and that sort of thing. But once that order is for relief, which means the petition's filed, not subject to dismissal, then there might be disputes that arise in the bankruptcy process that might be a contested or adversary proceeding. Again, we're going to cover that later in more detail, but for the purposes of administration of the estate, which is what our goal is today, we're looking at contested matters and is initiated by motion, application, or request. An adversary matter is brought by proceeding with a lawsuit filed in the bankruptcy court, because remember now the bankruptcy court has all the jurisdiction. So the different types of motions are available. We've got the motion to convert from Chapter 7, motion to dismiss the case, motion for change of venue, motion to enforce an automatic stay. That would be something on behalf of the debtor who is still being harassed or collection efforts still being made. Motion to avoid a judicial lien. Don't think I have anything else covering that, but if I have a judicial lien, like let's say I had a credit card and a lawsuit in the state court was brought, there is in fact a judicial lien placed on that debt, so I can avoid that debt in bankruptcy court. I can avoid the lien is what I'm doing. Basically, making it an unsecured non-priority claim if it falls into just the standard unsecured claim. Remembering that child support enforcement is not part of this, for example. An interested party might file a motion for relief from the automatic stay, asking if they can go ahead and harass and collect. Motion to dismiss the case, maybe there's a problem that the party in interest, like the trustee or the creditor, believes is a reason to dismiss it. Motion for abstention by the court. Motion for change of venue. Motion for disallowance of a claim. Motion for examination of any entity. The United States trustee might file a motion to dismiss the case, failure to file the schedules and statement of financial affairs. In the case of an individual debtor whose debts are primarily consumer debts, if they've abused the provisions of Chapter 7, perhaps the means test of income and expense insolvency basically is not met by the debtor, and that might be an area that the trustee would be interested in getting the case dismissed for. The bankruptcy court can dismiss the case for unreasonable delay, failure to pay installment on the filing fee. If they're primarily the abuse, same thing. The bankruptcy court may also, for the same reason, of abuse or failure to meet the means test, the bankruptcy court may make a motion. Complaints, creditors, complaint objecting to debtor's discharge, complaint objecting to the dischargeability of a debt, complaint objecting to debtor's discharge in the Chapter 7 world and the trustee world, and then the complaint to avoid pre-petition and post-petition transfers. That means that the debtor has transferred property or money. Pre-petition that doesn't fall into the bankruptcy code exceptions. So complaints might look like one of these, and the creditors, I just broke this down into a pretty little chart to kind of give you something to refer to. All right, order and notice of Chapter 7 bankruptcy filing, meeting of creditors, and fixing of dates. The clerk of the court notifies the debtor, trustee, all creditors, and indentured trustees of the meeting of creditors. The meeting of creditors, which is called the Section 341 meeting, must be held not less than 21 days or more than 40 days after the order for relief is entered. Objections by a party in interest to debtor's claims of exemptions. A creditor or Chapter 7 trustee may object to the debtor's claim of exemptions. So that means that maybe the debtor claimed property is exempt that's not considered exempt, and so that's on the schedule of exemptions. The objection may be filed within 30 days after the meeting of creditors is concluded, or after the filing of either an amendment to the list of property claimed as exempt, so it would be a schedule, or supplemental schedules. And if an objection to a claim of exemptions isn't timely filed, the exemption is allowed even if there's no colorable basis for the exemption that the debtor claimed. So the meeting of creditors and meeting of equity secured holders, this is often called the 341 meeting or Section 341 meeting. The trustee must call the meeting of creditors, but may call meeting of equity security holders. The meeting of creditors is called the 341 meeting. I've already said that. So within 7 days prior to the meeting of creditors, the individual debtor must provide a copy of the latest tax return, or the case gets dismissed. The Chapter 7 trustee presides at the meeting of creditors. Creditors are allowed to vote under the Bankruptcy Code, may request the election of a trustee. So if they're a different trustee, they may do that. If no election is requested, everything just goes status quo. The Chapter 7 trustee becomes the permanent Chapter 7 trustee. I hope you're noticing that as this set of video lectures begins to come together, more information comes and makes more sense of the more light touch that we use at the beginning. It all just scaffolds and builds on. So, the debtor is required to attend the meeting of creditors and they answer questions under oath. The trustee, creditors, indentured trustees, and the United States trustee can ask the debtor questions, and the debtor may appear and participate without being represented by an attorney. Equity security holder is a party who holds shares of stock or other evidence of an ownership interest in a corporation or limited partnership. The code authorizes the United States trustee to convene a meeting of equity security holders. That should be 11 U.S.C.A. I'm going to fix this real quick. So I fixed that, 11 U.S.C.A. Section 341B, so 341B. So generally it's not called Chapter 7 case because the estate's going to be liquidated. It's just typically not. Chapter 7 estate is generally a liquidation estate. So they're going to follow the standard exemption rules and that sort of thing. And other types of cases, chapters of cases, and equity security holders may have more frequent use of this. So redemption. Redemption is where an individual debtor under Chapter 7 can redeem certain property encumbered by a lien that can't be avoided. So I gave you the example of the credit card lawsuit. I guess a good example of redemption is a car that's basically what we would say upside down in equity. And they want to keep the car. The debtor satisfies the lien on the tangible personal property that secures the debt. But the value of the collateral is where they redeem to that point. So they're basically, the debtor is basically asserting that up to the value of the car, I redeem that car. And here's, generally speaking, back in my day when I did this, it was typically a cash redemption, if they had the cash or could find it. And some debt creditors will also work in tandem with a redemption or with a reaffirmation, which is the next slide. It's the debtor and creditor agree to survive the debtor's discharge, that the creditor will remain a creditor beyond discharge. It can modify the terms of the existing agreement, maybe changing the terms of the loan, the principal amount getting lowered. This kind of example, how these can work in tandem with the previous slide. debtor's intention to reaffirm must appear on the official form B8, which is done with the original filing. The motion for approval of the reaffirmation agreement is a procedural form, and the order on reaffirmation agreement is another procedural form. So back in the day, these were not always needing to be approved, but BAP CPA did place that onus on the debtor to ensure that the reaffirmation actually goes through a court approval process. Discharge. So at the time of the filing of the petition, we have an estate, and it can go in different paths. The debtor is seeking to be discharged from all of their dischargeable debts for a fresh start. Corporations, partnerships don't receive a discharge, but they cease to exist, as pointed out earlier in another video. And the trustee, meanwhile, is gathering and liquidating the estate to prepare it for distribution to the debtor and the creditors. It can be revoked by filing a complaint before the end of 1 year after discharge or the date the case was closed, whichever is later. And discharge may be revoked for fraud by filing a complaint within 1 year of date of discharge. So then we get to distribution of the estate. So the distribution takes place after the trustees collected the property and reduced it to money. Creditors holding secured claims, which are called perfected security interests under the Uniform Commercial Code, they'll receive their property or the value of their secured claims up to the value of the property. So the distribution goes like this. Unsecured priority claims are paid first because they're unsecured, they're priority claims. So not security or whether it's secured or unsecured, but their priority claims, the unsecured ones, will then be paid first. And then the unsecured non-priority claims will be paid. And there's some general guidelines there. And then the debtor, whatever is left. You know, folks, if you think about, if you've done estate probate work, this is very, very much like probate. I just have to say, I sometimes wish probate was handled more like bankruptcy when I was doing that kind of work, because it really is. This is a pretty clean and easy way to get through it. But anyway, that's my point. That's all. Closing the case is, closing begins with Chapter 7's trustees filing of a final report and proposed distribution of the assets. If you were to compare that to probate, that's like the trustee's plan. I'm sorry, the personal representative's plan of distribution. And once it's approved, the Chapter 7 trustee files a final report proposing how they'll be distributed and dealing with any fee applications. The bankruptcy court notifies all the creditors and other parties in interest of the trustee's final report and proposed distribution, and if there are any objections, they're due within 30 days. And after that trustee's final report and proposed distribution, if there are any rulings on objections, any adjustments made to the plan, the trustee distributes the assets of the estate. And then after they've been distributed, a final account reporting of distribution is prepared by the trustee. Trustee gets discharged. The case can be reopened to correct clerical errors if any took place during the administration of the estate, and the case can be reopened also to administer an asset or include another creditor if one was not included in the first place. So a quick review: Trustee Appointment and Powers. An interim Chapter 7 trustee is appointed at filing and becomes a permanent trustee unless another is elected prior to the 341 meeting. They administer the estate through liquidation of non-exempt, non-burdensome property. And Powers has including demanding property turnover, abandoning property, assuming or rejecting contracts, and avoiding various liens and fraudulent transfers. Claims and motions. Most Chapter 7 cases are no asset. Creditors are instructed not to file a proof of claim. If a dispute arises as to a contested matter, which is done by motion, or an adversary proceeding done by lawsuit, that's handled through the bankruptcy court. Motions can be filed by debtors, parties in interest, the U.S. trustee, or the court, and they address issues like dismissal, stay enforcement, and venue changes. Creditors, U.S. trustees, and U.S. trustees and debtors can file complaints objecting to discharge or dischargeability of debts to avoid transfers. So the 341 meeting of creditors is held 21 to 40 days after the relief orders and is presided over by the trustee. Debtor must attend and answer questions under oath. Equity security holder meetings are possible but rare in Chapter 7. Complaints can be filed by creditors, Chapter 7 trustees, U.S. trustees, and debtors, and they include objections to a debtor's discharge, objections to dischargeability of specific debts, and complaints to avoid the pre-petition and post-petition transfers. Debtors may also file complaints to determine the dischargeability of a debt. Meeting of creditors, kind of redundant, but that is a notification. That's a notification from the trustee, and it's scheduled within the allotted time, as previously discussed. If there are objections to debtors' claims of exemptions, the trustee may make that objection. If there's no timely objection filed to the trustee's objection, the exemption is allowed. I'm sorry, if there's no objection filed by the trustee, the exemption is allowed, even if it seems colorable. The U.S. trustee calls a meeting of creditors, can call a meeting of equity security holders. Chapter 7 trustee presides over 341 meetings, and debtors must attend. Redemption and reaffirmation means that the debtor may redeem lien-encumbered personal property by paying the creditor the collateral's value, and reaffirmation agreements allows the debts to survive discharge and can modify loan terms and require in their official forms required in court approval. Individual debtors seek discharge for a fresh start, and partnerships and corporations cease to exist without discharge. Discharge can be revoked within 1 year for fraud. Estate property is distributed first to secured creditors, then to unsecured priority claims, and followed by unsecured non-priority claims, and then finally to the debtor. Lastly, the case is closed. Trustee has proposes distribution, notifies the court. There's an objection period of 30 days, files a final account, and then requests case closure and discharge. They can reopen the case for asset administration or creditor inclusion. So this concludes this part 2 of the Voluntary Chapter 7 Bankruptcy Liquidation video lecture series. Thank you. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.